You may have seen in the news that Hugh Grant has settled his hacking claim against the newspaper. And he's put out a very good series of tweets explaining why he has done that. And it's all to do with something called Part 36 offers. So what I thought I would do is, I'll just give a general overview as to how the Part 36 procedure works, and that'll give you some context. I mean, I say the tweets are actually very, very good from a sort of layperson's perspective, but if I just explain the technicalities, it might make them even easier to understand, and also to explain why you can't read anything into a settlement. So, let's say there's litigation afoot. Either somebody has threatened litigation or somebody's actually issued a claim. Parties are encouraged to settle claims, and indeed 97% of all issued claims, that's claims where somebody's paid the court fee and it's all been served, they actually do settle before trial. So how do you do that? Well, either side can make an offer. The claimant can send the claim form saying, we want £100,000 off you. But they can actually send what we call a without prejudice offer saying, look, we'll take 75 or 50 or whatever. Similarly, a defendant can say, OK, you're wanting to sue me for £100,000, I'll give you £50,000 to go away. Now, this can all be done without any admission of liability or anything like that. But it's dealt with by what we call without prejudice. In other words, you can communicate and be completely open with each other. But those letters cannot be referred to in court if the matter doesn't settle and it goes to trial. So you can't say, well, hang on, Judge, they're now defending this claim, but they actually offered us money to go away, so clearly they know they did it. That just doesn't apply. We actually usually put without prejudice save as to costs because of the consequences. So what are the consequences? Well, say for instance one party makes an offer and that's rejected and it goes to trial. But at the trial, let's say the claimant wins. So they were suing for £100,000 and they win the trial. But the defendant had offered them, say, £80,000. And at the trial, the judge actually says, well, actually, I'm going to award you £79,000. So the claimant has failed to beat this offer. And that can be taken into account in costs. So, the losing defendant can say, well, hang on a second, we offered them more than this ages ago, so this trial's been completely unnecessary. They should pay the costs. Or similarly, loser always pays winner's costs anyway. So if somebody wins and says, well, actually, we offered to take less than this anyway, it doesn't really make too much of a difference there because, the loser would be paying the costs anyway. But the good thing about these sorts of offers, we sometimes call them Calderbank offers, because you can actually offer anything. You could sort of say, look, OK, in a defamation case, how about a retraction and an apology? You can offer something like that. It can be something completely unrelated to litigation. OK, we know you're suing us. How about if you don't sue us for this one, for this breach of contract, we guarantee you the next job that comes in, it's yours. Or we've got those other issues that we needed to sort out, transfer some land, something like that. You can basically offer anything for it to go away. And then this can all be recorded on the back of the court order. It's what we call Tomlin orders. I've done videos about those. And they become enforceable agreements. So you settle them through the court, but then if anybody was to breach that agreement, you could go back to court and say, please enforce this without issuing a fresh claim. So that's one way of doing it. However, there is a more formal method called the Part 36 procedure, because it's governed by Part 36 of the Civil Procedure Rules. And what that is either side, again, claimant or defendant, can make an offer, either pre-issue or post-issue. And they make an offer of money. Okay, this is the thing with the Part 36. You make an offer of money. So a defendant can say, in full and final settlement of this claim, we offer you this amount of money. Or a claimant can say, in full and final settlement of this claim, we would accept the following. Now, the thing there is, if the defendant accepts that, if they accept that offer, then the defendant is agreeing to pay the other side's costs. subject to assessment if they cannot be agreed. Now, if you want to make an offer where you want to be sure about what the costs are, and you say, okay, here's the we offer you this amount of damages and we'll also pay this amount towards your costs. If you make a fixed offer of costs, then that becomes a callback letter. It's not a Part 36 offer. But here's the thing with Part 36 offers. What happens if you fail to beat the offer? Well, again, you can refer to them after the trial. However, the deal is, if somebody rejects a Part 36 offer and then fails to beat that offer at trial, so say, for instance, you offer £80,000, that's rejected, and you get awarded the £79,000. The person rejecting the offer, the party, they have to pay the other side's costs on what we call an indemnity basis. So what's the difference? Well, normally costs are awarded on what we call a standard basis. And it's accepted you never get the full amount of your costs. You're looking to get 60 or 70% because what happens is the court assesses the costs. I mean, lawyers can charge their clients what they want. However, the other side, the losing side, doesn't necessarily have to agree to have paid your, whatever exorbitant rates you've agreed to. So you go through what we call the bill of costs, the schedule of costs, and every item has to be accounted for. Now, on a standard basis, you need to show that all expenditure was reasonably and necessarily incurred, and the overall cost is proportionate to the litigation as a whole. And it's for the receiving party, that is to say the party receiving the money, to prove that they are entitled to it. Indemnity basis shifts the burden. You still have to show the costs were reasonably and necessarily incurred. But it's for the paying party to show that they weren't. The starting position is, yes, all these costs are legit, unless you can argue otherwise. Also, the proportionality test disappears. So it could be a £100,000 claim and somebody's racked up £1 million worth of costs. Well, on a standard basis, they'd say, well, you're just not getting that as a matter of principle. But on an indemnity basis, that doesn't apply. So you can end up paying disproportionate amounts of costs. So why does this put pressure on people? Well, if you've got deep pockets and you just want to avoid a trial for whatever reason, I mean, it could be just completely commercial reasons. It's like, this is going to cost too much and take too much of our valuable time. It's just disproportionate because even if we win, we won't recover our full costs. Why bother? Let's just pay them something to go away. So that that is a legit reason. But it might be that you just don't want to go through the disclosure exercise, or you just don't want the publicity of a trial. Well, what you can do there is assess and say, well, what are the likely damages we're likely to pay at trial, if we lose, and offer more than that. Now, the thing then, if you offer more than that, even if the other party wants their day in court, they will be advised, well, look, even if you win this trial, you won't be awarded as much as that, so you would have to pay the other side's costs, and if they've done it as a Part 36, on an indemnity basis. So let's say you sue for £200,000. The other side could offer you £250,000, and you would be forced to accept that because if you went to trial, you'd never get that amount of money, so you would have to pay the other side's costs on an indemnity basis. So you'd be well out of pocket, even though you were morally right, legally right, and technically you won. And that's what's happened here. It appears that basically Murdoch has just made a Part 36 offer that is far in excess of anything that would ever be awarded at trial. So Hugh Grant has to accept that unless he wants to go to court. Because the thing to remember is, in this country, we don't really have a concept of punitive damages. Damages are purely compensatory. So they will look at and say, right, this defamation or this harassment or this old phone hacking, this intrusion in your privacy is worth this amount of money. This amount of money will put you back in the position you were if you hadn't been hacked. I mean, it's all very arbitrary, but we do it. We do it when people lose limbs, don't we? I'm sure most people say I'd rather have my arm than a massive wad of cash, but they just put a value. It's a book called Kemp and Kemp, actually. It just lists like every conceivable injury and how much it's worth. And that's the same with defamation, harassment, all civil litigation. You work out a price on it. And like I say, sometimes people take a risk and make it and say we'll offer under what we think they might get, but they might just accept it just for convenience sake. A couple of points to remember about Part 36 offers. When you make them, they're supposed to be open for a certain period of time, 28 days. But they stay open until you withdraw them. It's quite weird that. So even if you write and say, this is a Part 36 offer, it stays open for 28 days. If you don't formally write and say, by the way, it's now withdrawn, the party can turn up. See, you could actually get to the stage of trial because you can accept a Part 36 offer at any stage prior to judgment. So you could have the trial go, uh-oh, this isn't going to go well for us, and then say, okay, we'll accept the Part 36 offer. And the other side would probably say, well, hang on, it's too late now. But you can say, well, actually, you never withdrew it. so you see, we're doing that. And that has happened on occasions. But there you go. I mean, I hope that puts it into context. So you can see now people say, oh, why didn't Hugh Grant want his day in court? Because it would have made, financially no sense whatsoever. Now, just to bring a bit of Harry into this, because speaking of people with, sort of more money than sense, perhaps, it'll be interesting because he's like the last of the people hanging out on this. So presumably, they've made an offer to him as well, but he's presumably rejected it. So it'll be very interesting to see what happens when this gets to court. If Harry wins, whether he beats that offer and whether he ends up having to pay Murdoch's costs. Similarly, with that appeal, by the way, I just did that little video about, we predicted he'd get knocked back at the leave stage. Theoretically, it is open to Harry to apply to the appeal court and say, can I have permission? Now, bear in mind, he's got absolutely zero chance of doing this. It would be knocked back immediately. Will he risk doing it? Now, obviously, there's the money aspect, which he doesn't seem bothered about. But there's a real risk that this would be what we call a totally without merit application. The court could come back and say, we find this application was totally without merit. And that's like one of your sort of 2 or 3 strikes for being, on your way to being a vexatious litigant. I mean, he might risk it on the grounds that, well, this would just be in this one piece of litigation, and that would be the end of the road. So he bangs in his application for permission to appeal, gets knocked back, gets the totally without merit, but that is the end of it, and he's only clocked up 1 strike. But the danger is you could pick up strikes here, there, and everywhere, and eventually there is a danger that, the court will say, well, even though they're all in different bits of litigation, you clearly can't take no for an answer, so we're going to put a civil restraint order there, which would be highly embarrassing. So if I was going to do predictions, it's a difficult one. If his advisors will be saying, do not put in an application to the appeal court. But it wouldn't surprise me if he did. But if he does do that, I guarantee it'll be marked totally without merit. So there you go. That's one of my famous Mystic Al predictions. Anyway, as always, hope you found that vaguely useful, vaguely interesting. If you did, please consider liking, sharing, subscribing, etc. I would say hello from the boys, but they're over there at the moment because I'm a bit busy and poorly at the moment. So this was a very quick setup.